Joining me now is Canada's Justice Minister, David Lametti. Minister Lametti, thanks for joining us.
My pleasure.
Okay, we have to start, though, with the news that is being made today, and that is these reports out of the United States that the U.S. Justice Department is in negotiations for a type of deferred prosecution agreement that could see the release of Meng Wanzhou. Do you have any reaction for us on those reports?
I'm aware of the reports, but I obviously can't comment on them.
Okay. Have you been made aware of them through official channels?
Once again, it's not something that I can comment on.
Okay. But you were made aware of them around the same time that the reports were leaked to the Wall Street Journal?
I can't comment on any of the matter.
Okay. All right. Well, let's get to Bill C-7, which I know also is a big concern for you. This is the medical assistance in dying legislation, made some crucial changes. It's you're facing a court-imposed deadline of December 18th. The bill is still before the House of Commons. It's also still before the Senate. How confident are you that your new medical assistance in dying legislation will meet the deadline?
Well, I'm still optimistic. The Senate has done a pre-study, and I know that they have some concerns that they have raised. Once we get it to the Senate, we will undertake those discussions with them, and I'll make myself available to senators to make sure that their concerns are being heard. The main challenge right now is to get it out of the House of Commons, where, frankly, the Conservatives, a rump group of the Conservative Party, has basically co-opted their leader into allowing them to filibuster, notwithstanding a fair bit of support even in the Conservative Party, and certainly across the House of Commons and across Canada for this piece of legislation. So we hope that they'll do their duty and pass this legislation in third reading so that we can send it on to the Senate. Once it's there, I'm optimistic. Look, it's a tight deadline. I understand that, but I'm still optimistic that, again, this bill has the vast support of Canadians. We did do a great deal of consultation, including with disability communities who helped shape the legislation, quite frankly. And so we feel that we have met their concerns, and we're pushing to move forward with this.
So there is a forecast for the final vote in the House of Commons next week. Whether or not you have to use time allocation, that will come. But you mentioned the Senate. There are some very deep divisions showing up in the Senate. There are some profound concerns some of the senators are expressing. You know the Senate. You know they have a significantly wider margin in terms of length of debate. What are the chances that this will get pushed over until next year? This will not make the deadline in the Senate.
Well, we'll cross that bridge when we get to it. They have done a pre-study, which is helpful, so that we can get directly to their deliberations in the Senate chamber. Again, I'm willing to work with senators. I have heard their concerns to some extent. On the main question, I firmly and fully believe this bill is constitutional. That the carve-out exemption for mental illness being the sole criterion. It is temporary in the sense that we have always planned to study that in the further legislative review that is required by the 2016 law. But I do feel that it is constitutional. It's a very narrow carve-out, and we will get to those concerns, those very legitimate concerns. It's just that there is a deep division in the medical community about how to move forward, and failing that, it is difficult to see a way to move forward in a closer time.
You have had 2 extensions from the Quebec Superior Court to get this deadline, the current deadline of December 18th. Those who have these deep concerns about the bill, or those who want more time in the Senate, for example, say that you could simply go back to the Quebec Superior Court. They're saying that this deadline is largely self-imposed, largely arbitrary, and some of them also point out that the fact that the government actually prorogued Parliament for almost 50 days, that you could have gotten to this earlier. What are the chances of going to the court and asking for an extension?
Well, look, I'm not going to rule out any possibilities, but that being said, there's no guarantee of getting an extension. The court already gave us a second extension, and it really is up to them. They found the original law unconstitutional, or aspects of it unconstitutional, and that decision will stand if we don't get this law passed. So again, there are no guarantees on any of this. Even if I were to ask for another extension, there's no guarantee that the court would accord it.
Okay, and that would mean what? The entire law would be null and void, or just certain measures in it?
Certain measures in it would be have been found to be unconstitutional, so they would be inoperative in Quebec, but not in the rest of Canada. So that does two things. It creates a great deal of legal uncertainty in Quebec. So practitioners who want to be guided by the law in order to know what they are doing is legal or illegal, that degree of uncertainty may have quite a chilling effect on practitioners in Quebec. So I would say to my fellow Quebec MPs, and to Quebec senators, there is a great deal of negative impact for Quebec as well as for the rest of Canada. Then obviously in the rest of Canada, the law continues to stand, but then we have an unequal situation as between Quebec and the rest of Canada, and that in and of itself is the basis for a constitutional challenge. So it creates a very unhealthy situation both in Quebec and across the rest of Canada, and I would ask that MPs and senators take their responsibilities very seriously.
Okay, I want to get to, there's not much time left, but I want to get to another bill which you tabled this week, a monumental bill, Bill C-15, to harmonize Canada's laws with the United Nations Universal Declaration of the Rights of Indigenous People. Was widespread, this was welcomed by the Indigenous community in Canada, but some of people, including the National Chief of the Assembly First Nations, Perry Bellegarde, take issue with the fact that you're giving yourself 3 years to have a full action plan for harmonizing measures and taking action on systemic discrimination in Canada's laws. Could the time frame be shorter?
Well, we'll certainly look at that. We've worked closely with National Chief Bellegarde. We've worked closely with President Obed and National Spokesperson Chartrand, as well as other levels of Indigenous government across Canada. It's complex. There are a number of each nation is a nation with its own leadership, and so it is complex in terms of cooperation and co-development of an action plan. So the 3 years is meant to account for that. It's a challenging task, but it's one, frankly, that I or any one of my colleagues, I think, would gladly take on. That being said, we've worked with National Chief Bellegarde, and we have a parliamentary process. If we can be convinced that it can be done in less than 3 years, we'll obviously look at that. This is not going to be a point on which we will depart.
Okay, Minister Lametti, I want to thank you very much for taking the time.
My pleasure. Thank you.